What back to the Kennedy case here that's before the court. You say that it could go. The court could find in favor of Kennedy's right to pray at the 50-yard line, but you think it could be done in two ways. One of which is a kind of narrow ruling that you think is dodging what the real issue, and the other of which is actually to take the bull by the horns and deal with the problems and the mess that's been created over the last 50 years in this religious liberty area. So outline for the listeners what those two avenues could be.
Yeah, and there's probably more than two, but one way the court could rule in favor of the coach is simply to say, look, he's for purposes of his prayer after the game, he's just a private citizen. He's not acting in his official capacity. He's just taking a knee. So it's not state action. It's not the school district speech, and therefore there are really no constitutional concerns. They could even go a step further and saying his actions are protected under the free speech clause. But the easiest course would just be to say, look, this just he's taking a moment to on his own time, not interfering with his other school responsibilities. The actions are not ascribable to the school officials, and therefore there's no establishment clause violation. And that's a way to sort of let the coach pray or let coaches pray and not make the case a big deal. And that would be very much in the line of what the Chief Justice probably would want to do. It means in 2 years or in 2 months, we're not really even thinking about the case so much. An alternative, and this is the one I outline in the article, is the court, at least if there's 5 justices willing to do so, they could say what many of the justices have been saying for a long time. Our entire establishment clause jurisprudence has gone awry, and we really should set it straight. And you could say, I guess that's what I'm encouraging the court to do. Now they have to come up with an alternative understanding of the establishment clause, and that's also.
And you offer that,
and I offer that.
I mean, it's a kind of précis of the forthcoming book, I gather.
Yeah, a little bit. It's a part of it. That's right. And you can't beat something with nothing. And
it takes a plan to beat a plan.
Yeah,
it takes a test to beat a test.
That's right. And so I think so. I kind of knocked Justice Scalia in the piece in a friendly way. That Justice Scalia was very good at criticizing how the court got things wrong, but he never took the time to outline a sort of comprehensive doctrine of what the Establishment Clause actually prohibits. And so I'm trying to fill in the blanks there.
Well, let's hope it does. Thanks for your time, and thanks for this great piece. And I look forward to the book, which is, again, Religious Liberty and the American Founding. And when is that coming out?
Sometimes this summer, I think later in the summer.
All right. Very good. All right. Thanks again.